Welcome to MSL Presents A Question of Law. Our show today explores the landlord versus tenant controversy. In the half hour that follows, we will explore the balance of power in the legal and economic relationship of residential landlords and tenants. We'll do this by discussing some of the laws on the books, and then you decide whether it's the landlord or the tenant who is best served by the law. Joining me today is attorney G. Emil Ward, who has been practicing law for over 19 years in downtown Boston. He concentrates in civil litigation, real estate, and insurance law. He is the author of a book entitled Massachusetts Landlord-Tenant Practice, Law and Form. Welcome, Emil.
Thank you.
And attorney Fairlie Dalton from Neighborhood Legal Services in Lawrence, Massachusetts. Fairlie represents low-income tenants in eviction and sanitary code enforcement matters. And she is a lecturer for the Massachusetts Continuing Legal Education on Housing Court Practice. Delighted you're with us, Fairlie.
Thank you.
And attorney Peter Malaguti, a professor at the Massachusetts School of Law in Andover, Massachusetts, where he teaches courses in property, conveyancing, landlord-tenant rights, and local government law. Thanks for coming, Pete.
Thanks, Diane.
And I'm Diane Sullivan, a professor at MSL. Let's begin by exploring the balance of power historically between landlords and tenants. Peter, historically, who has been better off, the landlord or the tenant?
Somewhat a long answer, Diane. There is a long, rich history to landlord-tenant law, and the roots are contained in medieval England. Beginning about 500 years ago, the current law, as we've come to know it, began. For most of those 500 years, it hasn't changed very much. It has been pro-landlord. In medieval England, the land was considered to be the most important part of the lease. Tenants were most interested in being able to grow crops on the land and being able to harvest the land. If the house burned down or if there were other problems with the land, the tenant, who was pretty handy, could just rebuild the house. As long as he or she had the crops, that was the important thing. It wasn't until about 1960 that the law started to evolve a bit and give the tenant some rights. So if I had to choose historically who's been benefited by the relationship, if we look at all the years, we'd have to say the landlord.
Thank you, Peter. Emil, despite the television news coverage where we occasionally will see a landlord who's been thrown into jail or a slumlord who is forced to live in the same squalid conditions as their tenant, the image of a landlord as a victim is just not one that I often visualize. I don't know about you. But can we really go so far as to call the landlord a victim?
Well, I would say today in many instances, especially with the smaller landlords, there are problems, and some of them do become victimized by the tenants because there's a system in Massachusetts that is very, very strong now in favor of the tenants. You have the housing courts, you have security deposit laws, you recently had rent control laws that just went out, and you have a matrix of some other laws that operate to put, especially a small landlord, at a competitive disadvantage today.
Thank you, Emil. Peter, are the laws that one-sided in favor of the small landlord?
Well, it's clear that if you counted up the number of laws that are on the books today, clearly the bulk of them would in fact favor the tenant. Mm-hmm. They seem to be there to prevent the types of evils that many tenants complain of. But the inquiry, it must be a much larger inquiry than that. You've got to take into account the economic positions of landlords and tenants as well, and also consider that many of these laws were passed to address specific situations that landlords caused. So while the books do protect the tenants more, I believe the legislatures are trying to get to an equal position between the landlords and the tenants economically.
To a balance?
Yeah, some type of a balance.
Fairlie, you represent tenants. Who's the victim?
Well, I don't usually advise my clients to think of themselves as victims, for sure. But I think in the economic balance of power, tenants are on the short end of the stick, usually. The tenants have a lot more to lose in the landlord-tenant relationship. It is, after all, their home. And they are usually in a less stable economic position. So that while the laws may favor tenants, I think the purpose of the laws is to even out that balance between the tenant and the landlord.
I think that's a good observation. Fairlie, in your view, how far do tenants have to go to achieve rough equality in the landlord-tenant relationship?
Well, I think there are two things. First of all, I think tenants need to be more educated about what the laws actually say as to their rights and their responsibilities. And a lot of that is done through education of tenants. And the second problem area, I think, is the very small number of tenants that are represented by attorneys in enforcement proceedings. Most tenants are actually pro se, whether in the district courts or the housing courts in Massachusetts. There's a great inequality of power when landlords tend more often to be represented and tenants do not.
Fairlie, many of the landlord attorneys attribute some of the current woes that landlords have to the public legal service lawyer. And I wonder if you could take a moment for the audience and explain, what is a public legal service lawyer? I mean, specifically, what do you do?
Okay. Well, legal services was funded originally in the 1960s in response to the riots that swept the country. There was a perception that a large segment of the population did not have access to the courts and did not have a voice. In response to that, a national legal services system was established. For a long time, there had been legal aid societies, especially in the larger cities, that helped poor people. But this was the first time that there was an organized legal services system that covered every area of the United States. We do basically core services, which includes housing, representing tenants that are being evicted in evictions or that are in danger of losing their housing subsidy with the housing authority. We do family law work, most often now with victims of domestic violence. We do access to health care and benefits.
Thank you, Fairlie. Emil, would you like to supplement or somehow disagree with Fairlie's description of a public service lawyer?
Yes. Legal services, for a long time, I feel, has been out of control in many ways. For instance, in Boston, I had a case several years ago where the owner of a two-family had a tenant, and her boyfriend died, and she went to my client and said, well, look, can I lower the rent to $600 a month for the next 3 months while I find a place to live from $900? He said, fine. Well, 3 months came and went, 12 months came and went. 18 months later, when the relationship is kind of frayed and there's slow payments and no payments for a while, they call me in. We move the case to trial. And I'm talking to legal services on the other side, and they're asking me for another year to allow her to move. And I asked the legal services person, I said, when's enough enough? He said, well, frankly, we kind of have a policy where we just can't advise these people to move out, to give up a tenancy. So I think there are times, certainly, when legal services may go just a little too far in their representation. And of course, then the landlord has a difficulty competing in terms of the man or woman hours that the legal services attorney can put in, because lawyers such as myself have to be paid by the hour.
Okay, thank you. Fairlie, who is entitled to a legal service lawyer?
Actually, no one is entitled to one. It's not an entitlement program. There are eligibility requirements. Households are eligible for legal services if their gross income is below 125% of the federal poverty level.
Have you observed any type of abuse in the qualification process?
I have to say, I've been practicing for almost 15 years in legal services, and I haven't. There's a screening process that each person must go through. If there is any question on the initial eligibility, we ask for verification, for third-party verification of person's income. There are a lot of people who would like services. We're not able to serve even half of the people who come to our doors.
Thank you, Fairlie. Emil, would you agree that only indigent persons are represented by legal service lawyers?
Well, I would hope that's the case, but unfortunately my personal experience is a little different. For instance, I had a case in the housing court several years ago where the legal services attorney represented 2 of the tenants who were indigent and were eligible for his services, but the third one he admitted was not eligible for his services, but when it came time to go to trial or default, he filed an appearance for this person anyway.
Well, how does he get away with that?
Well, I didn't push it at the time because we settled the case, and I didn't feel that that was going to be tactically to our advantage to go after legal services in that regard. But I'm sure it happens as often as not.
Peter, your reaction to this?
I can react in a couple of ways. First of all, lawyers are lawyers. All lawyers are required to represent their clients as zealously as possible within the bounds of the law. That's going to be true in regard to landlords' lawyers, and it's also going to be true in regard to tenants' lawyers. Legal services lawyers are lawyers, and they are going to try to represent their clients zealously. Sometimes the goal is to win the case and keep the tenant in the apartment. Sometimes the goal is to keep the tenant in the apartment just a little bit longer before the eventuality occurs the tenant has to leave. I've only seen one abuse of the indigency requirement for legal services lawyers in my 16 years. So I assume that most of the time the process is not abused.
Thank you, Peter. Emil, landlords often complain that the numerous laws on the books have affected their very ability to make a profit from their investments. Is it truly that bad for landlords?
Well, in some cases, yes. In some cases, no. But again, the smaller landlords are the ones who really kind of take the hit in this particular case. For instance, the laws are set up such that if a tenant opposes a non-payment eviction, the tenant can stop paying rent either before or after ISD comes in and have virtually a free ride until the matter comes to trial.
I'm going to interrupt you for a moment and ask you what you mean for the audience by IDS or?
Sure, ISD.
ISD.
Inspectional Services Department.
All right, thank you.
And that's the local board of health for any city and town.
Okay.
That's important for them to call them in at some point to verify that there are in fact defects to provide a basis for some of their defenses, potential defenses. But the point is here is that while the litigation is going on, the tenant is not required by Massachusetts law to escrow. That's a commonly held misconception. Yes, it works out at some point in the calculus that if they want to maintain possession after trial, they have to pay over whatever the judge decides they owe after deducting what the landlord owes them. But there is no legal requirement, as there is in some other jurisdictions, for them to escrow that money as they go. If that were a requirement, I think the playing field would be much more level landlords.
Fairlie?
Well, I think I've heard this comment several times. I think especially with small landlords, what I have encountered is landlords who get into the business and don't realize that it's a business. This is not just a hobby that people engage in. It is a business that has expenses. There are costs that must be incurred. It is not 100% profit, which I think sometimes comes as a surprise, especially to smaller landlords. In terms of what Emil mentioned about the rent escrow account, which is not currently on the books in Massachusetts, tenants do need to have the money saved if they are going to maintain possession of the apartment. And that is something that judges will order. Tenants actually, after an eviction case goes to judgment, will have 7 days to pay the balance that the judge has determined is owed if they're going to keep possession of the apartment. Many housing court judges also will order tenants to pay the money into court if they feel that the case is going to be protracted in any way.
Thank you, Fairlie. Let's go from the general to the specific. I'd like to look at some of the laws that are on the books governing the landlord-tenant relationship. Peter, I wonder if you could describe generally the security deposit law that we often hear so much about.
Sure, Diane. Every New England state has a security deposit law on the books. Every one governs the ability of the landlord to collect a security deposit. It's a matter of fairly common practice for landlords to take security deposits from tenants in case the premises is damaged or in case the tenant fails to pay rent. And there's certainly nothing wrong with a landlord doing that. Every state, however, regulates that to differing degrees. Massachusetts tends to regulate it to a fairly high degree. The security deposit laws generally tell a landlord how much he or she can collect. 1 month, 2 months, 3 months, something like that. They tell the landlord what type of receipts the landlord is required to give a tenant. Most of the time the landlord has to inform the tenant where the money is located, things like that. The security deposit statutes require that the money be kept separate from the landlord's money, so the landlord can't get after it to get at it to pay his bills. And then the security deposit statutes tend to provide penalties for landlords who either misuse the money or fail to give the proper receipts or fail to return the money when that's required by law.
Thank you, Peter. Fairlie, is it fair to impose all of this on landlords, and if they don't follow all of the strictures of the law, they're going to be subject to triple damages and attorney's fees?
Well, I think it's almost a necessity because the concept behind the security deposit is that the money is the tenant's money until such time as there are damages to the apartment. And certainly the law was enacted to remedy certain defects, such as landlords not having the money available when the time came to refund it to the tenants. So the law is there requiring that the money be kept in a separate escrow account so that it will be there when it's needed without a lot of protracted litigation. I think secondly, the penalties are there as an incentive, certainly. Despite a lot of comments, and there'll be some disagreement, I'm sure, the requirements of the security deposit law are not really that difficult. There are forms available for landlords they're available from real estate boards, which have been tried and tested, and if they're followed, landlords will not get in trouble on the security deposit law.
But it's got to be a hassle if a landlord has a lot of tenants, Fairlie.
Well, I guess it goes back to my point that this is a business. It may be a hassle to some small degree, but it's one of the costs of doing business, to learn the law, and if you choose to take a security deposit, to learn how to do it correctly.
Emil, your views on the security deposit law?
I advise most of my landlord clients not to take a security deposit because the 15 or 16-page statute, Chapter 186, Section 15B, is too onerous. There are too many requirements. You have to give a statement of conditions within 10 days of the tenant's moving in, and then you go back and forth. If the tenant doesn't agree with what the landlord wrote down, they have to respond within so many days so that you have a snapshot of what condition the apartment was in. You have to put it in an escrow, interest-bearing escrow account separate from your own. You have to deliver a receipt that gives the name, the place, the account number, that sort of thing. Then you have to keep records as a landlord of these defects and these statement of conditions for X number of years. Then if you fail that, there are certain provisions, immediate return of the deposit upon the tenant's demand, and if you fail to return that deposit within X amount of time, triple damages. Then a landlord has the following. If you even go to court with this, if you decide you're going to go to court and you lose, in order to appeal, the landlord has to put up a bond that's 3 times the damages. It's too onerous.
But as Fairlie says, it's just the cost of doing business, Emil.
And the cost is too high for the $500 or $1,000 that you hope to recoup by the simple expedient of holding the tenant's money.
Peter, do you agree with the regulation?
I agree with the regulation. I agree that there should be some type of security deposit law. And I agree that in regard to landlords who own many, many units, that there's really no excuse for not following it. I think the burden falls on the smaller landlord who maybe owns a 2-family house, lives in the bottom unit and rents out the top unit. As Emil suggested, the statute is a leviathan, and it's sort of been compiled the way that much legislation is compiled. Layers have been added over the years. It's disorganized. It's hard to read. And because of that, I think a lot of small landlords are at a disadvantage. But I do agree there should be a security deposit statute on the books.
Thanks, Peter. Let's talk now about reprisal statutes. I wonder if you could tell the audience, Peter, generally what we mean by a reprisal statute.
Sure. There are 2 phrases. Often reprisal is used, sometimes retaliatory eviction is used. Again, all 6 New England states have statutes prohibiting a landlord from engaging in a retaliatory eviction or a reprisal eviction. Let's set the stage. In the past 30 years, 40 years, an awful lot of laws have been passed that protect tenants. State sanitary codes or housing codes. And obviously the tenants have taken advantage of those laws. They very often call in inspectional services if they have a defect. Well, unfortunately, many of the laws that are written by the 1% of, written for the 1% of bad landlords who are in fact evil landlords. So somewhere along the line, landlords started evicting people who would report them for having unsanitary conditions. So the legislatures of all 6 New England states decided that they would pass this reprisal statute, at least curtailing the ability of landlords to evict. What most of these do is list a number of protected activities that a tenant can engage in, and then say that for a period of, say, 6 months, a landlord cannot evict a tenant who is engaged in one of those protected activities.
Well, you mean something like reporting to the housing department some type of a violation?
The typical protected activities are reporting a violation to a health department, bringing a court action, forming a tenants union, or complaining in writing to the landlord. Those are the typical protected activities. And for 6 months, the landlord evicts the tenant at his or her risk. essentially. And of course, the reprisal statutes provide for penalties if, in fact, the landlord does evict within that 6 months and doesn't have just cause to do so.
Thank you, Peter. Emil, why do the landlords think this is so unfair?
Well, because within this 6-month period that a tenant can perform this act, a rebuttable presumption arises against the landlord that the landlord is changing the terms of the tenancy, for instance, sending a notice to quit or evicting, in reprisal for the tenant having done some protected act. Not only is that presumption, I think, unfair, but in this state, in Massachusetts, the landlord can only rebut that presumption by producing clear and convincing evidence that it's not a retaliatory eviction. Now, that's somewhere between beyond a reasonable doubt, the criminal standard, and the usual civil standard, which is only 51%. So we landlords generally think that's unfair to increase, to raise the bar.
Fairlie, I'd like your reaction to that, because I'm sure that you think the reprisal statute is a necessity. But when the normal civil standard of proof is a preponderance of the evidence, isn't it unfair to create a presumption in favor of rebuttal in a situation such as this? We don't even do this in racial discrimination cases.
I think it's not unfair in the context of this particular situation. And I would add to what Peter said, it's not so much that the landlord cannot bring any retaliatory action for 6 months. In fact, the landlord can never retaliate against the tenant. It's just for these first 6 months there is this rebuttable presumption which is there. The standard is clear and convincing evidence in this state. I think part of the reason for that is that the right that we're protecting really is a First Amendment right. It's the tenant's right to complain in writing about inhuman or subhuman conditions of living. So it's their First Amendment right to speak and to complain and to be heard, not necessarily by the sovereign in this case, but certainly by their landlord, who for many tenants is close to the sovereign in terms of the balance of power.
Thanks, Fairlie. Peter, I've often heard that tenants are entitled to something we call quiet enjoyment. What does that mean?
Quiet enjoyment is a term of art. It's a right that a tenant has in the property, and it's a right that's been around for several hundred years, again back to medieval England. Generally, tenants are entitled to the peaceful possession of their premises. Now, at early common law, and again right up until the past 20 or 30 years, the rights of the tenant to complain about quiet enjoyment were fairly limited. The tenant had to show that the landlord himself or herself interfered with the right to quiet enjoyment and had to show that it was a substantial breach of quiet enjoyment. So things like turning off the tenant's water, hot water, creating loud noises, matters like that typically result in a breach of quiet enjoyment. Massachusetts has passed a statute, Chapter 186, Section 14, which has made the right statutory, and which also has expanded the tenant's rights quite broadly. And we've got to the point where we don't have to quite show intent on the part of the landlord or that it was the landlord himself that caused the breach anymore.
Thank you, Peter. Let's talk about Massachusetts just by way of example, Emil. This chapter 186, section 14. It appears to expose a landlord who might just take a little bit too long to respond to a tenant's complaint to all kinds of things like triple damages, attorney's fees, and potentially even a criminal record. I mean, hasn't the court gone too far at this point?
Well, I believe that the legislature has in enacting this statute this way, and I think that the courts have too in taking away a reasonableness from the landlord's arsenal of defenses, if you will, in terms of how long it takes them and how well they address the violations that are complained of. Under Massachusetts law, you have this statute plays in with the warranty of habitability, which is a strict liability concept, which means from the moment that the landlord has noticed that there's a defect, the landlord is liable for diminished value, paying it back to the tenant at some point of the apartment until they fix it. And the courts have said that there is no room for, excuse me, for reasonableness of your efforts or the time that you take to address it. You either fix it or you don't. And this plays into 186.14 in even allowing the statute to be triggered through just mere negligence. It doesn't have any reasonableness defense for the landlord in it.
How do you justify it fairly?
Well, I think maybe by saying there is no reasonable way to live in an apartment that has no water or no heat or no electricity. I think as a society we say that people are entitled to live in rental units that meet certain minimum standards, and there are certain standards that we just will not go below. And an apartment that is, the statute refers to conditions in an apartment that are really outrageous, that no one would live in. And in those situations, treble damages are imposed because of the nature of the conditions, really, and the landlord's ability to fix them, to get it done.
Thank you, Fairlie. You look like you just
Yes,
need to say something.
Well, I would like to interject that the statute itself does not delineate what triggers a violation, what some judge would find as a violation. Some of the cases, however, say a lot of little violations would trigger the statute. One big one would trigger the statute. And I think perhaps part of the problem here is that it is so nebulous and there's so much discretion from judge to judge. If it were just no heat, no hot water, I could understand imposing some sort of urgent remedy upon a landlord to get him or her to do the right thing. But when you have a list of violations that have existed for months that don't come to the landlord's attention until the landlord files a case for non-payment, and then you put them into this statute and seek these damages, I think it's unfair.
Fairlie?
Well, I have to say, in my experience, damages have only been imposed under this statute in really extreme conditions. There may be conditions that are not specifically no heat or no hot water. They've existed for a long time, but I think any reasonable person looking at them would think these really materially affected the person's ability to use their apartment for the normal living purposes.
Because we're quickly running out of time here, Emil, I'd like you to take, if you could, 30 seconds and sum up the position of the landlord.
Well, I think that the statutes that are currently on the book are very much in favor of the tenant. I think that there needs to be some intervention on the part of the legislature, specifically with one instance that I mentioned regarding the possibly posting of the rent into court, where the tenant is being sued for non-payment. That changed the whole impetus, the whole energy. The tenant would now be moving ahead towards resolution instead of having an incentive to drag his or her feet. I think that there's some more fairness that needs to come into some of these statutes.
Thank you so much. Fairlie?
Well, I think the laws as we have put them together so far are really just an attempt to correct an imbalance that existed. And I think that the tenants have a real interest in the landlord-tenant relationship, in maintaining a good relationship and in maintaining their homes. And I think the laws as they now exist give them the opportunity to do that.
Thank you, Fairlie. Peter?
I think most of the laws that are on the books are justified to one degree or another. If I were going to criticize the laws of the 6 New England states, I think I would do so by saying that they're a bit disorganized. If any legislative work is going to be done, I would like to see the language cleaned up. I would like to see the laws put in more unambiguous terms, in terms that lay people can understand. And I'll leave it at that.
Thanks, Peter. Before we go, one last question I'd like to ask you. What are your views on rent control and the elimination of rent control in Brooklyn and Cambridge and everywhere else, because Massachusetts voters have eliminated that?
Well, the Massachusetts voters have certainly spoken. There's no doubt about that, and rent control is gone. I think that's mainly a reaction to what Americans tend to like as the free market system. And we've all heard horror stories about wealthy tenants living in rent-controlled property, paying only a few $100s a month. And I think that's a large part of what the voters' reaction was to that. But rent control is gone in Massachusetts, and we don't have it anymore.
Thanks a lot, Peter. Well, who's better off? I'm going to let you decide that question. What you believe, though, probably depends upon your own economic circumstances. Clearly, persons who own rental property think tenants have all the ammunition, and renters think it's the landlord has the upper hand. So you decide what you think. We're out of time. I want to thank our guests, Fairlie, Emil, Peter. Thanks so much for joining us. And to our viewing audience, until next time, be well. Thank you.